Vrinda and I decided to do it this way, that I would speak about the history of the Uniform Civil Code, and Vrinda, who has studied the Uttarakhand Code quite seriously, she will, among other things, focus on that. I also want to start by saying that I want us to think about the fact that the problem of the Uniform Civil Code is not only that it is patriarchal. I mean to say that, let's say the Uttarakhand Code had not been passed, we still had problems with the Uniform Civil Code. So I want us to remember that there can be, that at least I personally and a large part of the feminist movements in India are opposed to the very idea of a Uniform Civil Code. And I think this is something that we need to keep in mind. So it's not just that there's a bad Uniform Civil Code which has come from Uttarakhand and there could be a good Uniform Civil Code. We are opposed to that. So, some of the things I say you might know, some you may not know, but I'm going to go very quickly through the history of the Civil Code. So this idea goes back to the 30s, to the 1930s. And initially, in the 30s, there was quite a push on the part of women activists and the AIWC at that time for a Uniform Civil Code. And the demand for a Uniform Civil Code more or less went on till, it's only in the 90s that the women's movement, so you'll also see that sometimes I'm saying women's movement and sometimes I'm saying feminist movement. We used to call it the women's movement till fairly recently, but now we prefer, for obvious reasons, to call it the feminist movement, because people of all genders are part of the queer feminist movement. But till the 90s, we called it the women's movement, we called ourselves the women's movement, Mahila Andolan, Jo Bhi Tha, we used terms like that. So till the 90s, there was actually a push for the Uniform Civil Code, but from the 90s, the position of the women's movement of the time also changed. And ever since then, there have been very complex arguments that have been made by many scholars and activists. But somehow the voices of feminists never reached the mainstream. So if you think about the Uniform Civil Code, it's always seen as a choice between national integrity, that is, if you're for a Uniform Civil Code, you're for national integrity, and if you're against the Uniform Civil Code, you are a community that is defending your cultural rights. So it's always presented as if the choice is between these two. But of course, we have been making much more complex arguments. And those complex arguments have to do with gender justice. So now, when the BJP routinely invokes some idea of gender justice in its various policies, that is actually a very distorted and very it's like a caricature of what we could call gender justice. But you will see the BJP invoking gender justice when it talks about the Uniform Civil Code now. And so for over 8 decades, more than 8 decades, from the 1930s, the women's movement has debated among ourselves also the desirability of a UCC, replacing various personal laws which are applicable to the various religious communities. And all these laws have discriminated against women in relation to marriage, divorce, inheritance, the custody of children, and so on, right? But somehow that was not the way it was talked about. So what we need to ask is, why uniformity? What is the value of uniformity? And how does uniformity or national integrity, if uniformity is important for national integrity, how does that benefit the woman who is at the receiving end of domestic abuse, injustice, and so on? How does uniformity help the woman who is at the receiving end of discriminatory laws? It's a question that we need to ask. Uniformity is not a constitutional value. Uniformity does not mean equality or gender justice. Uniformity means sameness. That's all it means. Why is there such a value attributed to something which is simply about sameness? And if you're going to talk about sameness, then it implies a uniform standard which everybody will have to meet. And the question is, who will decide this uniform standard? What will this uniform standard be? Uniformity is the strategy that is used by authoritarian regimes to homogenize populations and to make them amenable to greater control by the state. This was also the British colonial project. What Hindu Rashtra wants today is what the British colonial project was, to homogenize the population, make it legible to the state and to control it. And the different personal laws for different communities were prepared under colonialism by treating each community as if it were homogeneous, as if there was no heterogeneity within these communities. So when the religious personal laws were being formed under colonialism and coming into being under colonialism, the colonial state was recognizing only the powerful voices within each community, and those would be the dominant male voices, those who claimed the power of scriptures, etc. So the BJP's push also to implement a UCC cannot be seen outside the overall context of the Hindu Rashtra project, which is, and you can see all the other elements of that project. You have to see the UCC in the context of the elements of the Hindu Rashtra project, which includes discriminatory legislation such as the CAA, the overall atmosphere of intimidation and violence against minorities and Dalits that this regime has presided over since 2014. And the invocation of uniformity is therefore a project, is part of the project of carrying forward a colonial legacy so that was a project of British colonialism. This is a project of Brahminical colonialism. So the Hindutva project of decolonizing is really a project of recolonizing the heterogeneity of communities that are not communities that are not Muslim, Sikh, Christian or Parsi. It's a very heterogeneous set of communities we have. That is the definition of Hindu. You all know that. Under the law, you're a Hindu if you're not Muslim, Christian, Jewish or Parsi. So these heterogeneous communities are being, the attempt is to Brahminize them, and that is the project that they're calling decolonial. So this project, you see the beginning of, so it was not always a Hindu Rashtra project, but any kind of project that the nation state has undertaken acquires a particular form under Hindu Rashtra. So if you go back to, so this project is an older project of homogenizing communities. So the codification of Hindu law in 1955 and 1956 established this definition of Hindu that I just said, all communities that are not. And it also established a certain uniformity for a range of heterogeneous communities. But this uniformity, in fact, deprived women of many communities from the better rights to property and in marriage than they had previously. That is to say, when these acts were passed, the Hindu code bills were passed, and it codified Hindu law, what was called Hindu law, the baseline was the condition of Brahmin women, which was the worst. So the Hindu law, the codified law improved the condition of Brahmin women, but it empowered Brahmin women to some extent, but it took away, for example, from other communities, for example, Jain widows, the much better provisions that they previously had under their own customary law. So the codification of quote-unquote Hindu practices essentially took away the rights of many other communities which had better laws. The Hindu Succession Act, for example, nullified the better condition of daughters under matrilineal laws, making sons equal inheritors. And originally, Dr. Ambedkar had said that matrilineal communities should be exempted from the provisions, purview of the Hindu Code Bill, but that exemption was removed. While empowering men under matrilineal, so under matrilineal men were empowered, but the Hindu Succession Act refused women from non-matrilineal communities, the vast majority, rights to co-pastoral property, a situation that was rectified in 2005. I'll come to this business about individual rights to land at the end of my talk, but it's not a very simple, progressive development for women to get rights to co-passing land, and I'll say why. So what you're saying is that the so-called reformed law was actually just a codified law. When you codify something, there's a uniform standard. That standard was the condition of Brahmin women who were much worse off. So improving their condition, but making that then the baseline for all communities meant that many other better practices of marriage, inheritance, custody of children were removed for other non-Brahmin communities. The only example of a uniform code in India that we have is the Portuguese Civil Procedure Code, passed in 1939, which Goa has, which is neither uniform nor gender just. So this term just gets tossed around. The positive aspect of Goa's, so what happens under this code is that marriage law, so it's neither uniform nor gender just. Marriage laws differ for Catholics and people of other faiths. If a marriage is solemnized in church, then church law applies, which permits, for example, the arbitrary annulment at the behest of any one of the parties. The customs and usages of the Hindus of Goa are recognized under this so-called Uniform Code of Goa, which includes limited, quote-unquote, limited polygamy for Hindus. The positive aspect of Goa's civil code is the community property law, which guarantees each spouse 50% of all assets owned and inheritable at the time of marriage. But this provision can be sidestepped in practice given the power relations in a marriage, and studies show it has not made any impact on incidences of domestic violence. So if you don't prioritize gender justice, basically, it does not, uniformity and the lack of uniformity both can reinforce patriarchy and majoritarianism, as the example of the Goa Civil Code shows. So gender justice must be prioritized, not uniformity. Now, the reason UCC is in the directive principles of part of the Constitution and not the fundamental rights is because the Constituent Assembly came to the understanding that the diversity of practices in this country was so great, they wanted not to override them by one law, but to maintain as a horizon the possibility of a common set of laws that would embody the values of the preamble. So the term or the words used about the directive, about the UCC and the directive principles is the state shall endeavor to establish a uniform civil code, although it's not spelled out why this is desirable. At the same time, and this has been pointed out by many feminists, including Vrinda, that the directive principles also call for a number of other goals that the state should endeavor to bring about. There are other directive principles. Let's talk about those. What are those other directive principles? Participation of workers in management of industries. Free and compulsory education for all children under the age of 14. To protect every monument of historic interest from disfigurement and destruction. Why only after the UCC? What about these? These are also directive principles. From the Manusmriti to the functioning of present-day laws, discriminate. So what we're really saying is that, so I'm saying that from the Manusmriti to present-day laws, discrimination is there. Discrimination protecting the powerful is evident in practice, sometimes in theory. So when we question the value of uniformity, the opposite of that is not discrimination. For us, the opposite of uniformity is diversity. So we are not justifying discrimination, we are saying we need to protect diversity. So again and again what happens with the UCC is that it is talked about as if its value is self-evident. Once you say the Uniform Civil Code, then all other conversation has to immediately stop. There's a way in which, for example, these are the ways in which the Vice President put it some months ago. A UCC will bind the nation more effectively. Not clear why. How will the UCC bind the nation more effectively? Also that not to have the UCC is corrosive to our values. So at that point, we were still saying, okay, what are these values that not having a UCC is corrosive to? As we will see when Vrinda starts speaking, we know what those values are now, because Uttarakhand has shown us our Brahminical, patriarchal values are what the absence of a UCC is corrosive to. The absence of a UCC does not permit us to establish Brahminical, patriarchal values as the norm. So what is nice or what is interesting or good about the BJP is that they just spell it out for you. The Uttarakhand Uniform Civil Code is like a charter of Brahminical patriarchy. When Uma Chakravarti used this term Brahminical patriarchy first, it took a long time for people to understand. Now we can just hand them the Uttarakhand Civil Code. This is Brahminical patriarchy. So we are objecting to the Uniform Civil Code for these reasons. There are other. So the second set. So we are opposed to uniformity per se. Any democracy should be, any democratic functioning has to object to democracy per se. Heterogeneity is the condition of democracy. And nowhere in the world is it said, nowhere in legal scholarship, nowhere in legal practice, is it assumed that one law or uniform law is more just than a multiplicity of laws. There is no such, no argument can be made for this, no argument has been made for it, not by these people either. Uniformity is not a value that we defend at all, and uniformity can only be authoritarian, it can only represent dominant values. The second set of questions that I want to quickly raise is that you'll hear sometimes, it's said sometimes. Now, after the Uttarakhand Civil Code, all bets are off, because now we are no longer speculating about what a uniform civil code will look like. But I did want to initially, as I said, say that uniformity is a value that we should reject unilaterally, even if it is a uniform, there will not be one, but even if it is a uniform code created by feminists, right? Even so, uniformity is not, feminists won't do that, so we have to reject uniformity. Now, what the second part of my presentation has to do with what could a UCC look like if it were not the Uttarakhand Code. So this is what I began to say. There are a number of times we have heard those who are in favor, the BJP leaders who are in, the BJP is in favor of a uniform civil code, and they used to say, in the 90s at least, this was an argument that they used to make, that a uniform civil code will take the best parts of every religious personal law and make that into the code. But what would that look like? Let's consider some possibilities. So first, if polygamy and arbitrary divorce, as permitted by Muslim personal law, should be outlawed, as they are in Hindu personal law. Polygamy and arbitrary divorce are outlawed in Hindu personal law. Conversely, we need to consider the situation of the Hindu undivided family. Now, after the passing of the Bharat Nyaya Samhita recently, I'm not completely clear about the status of the Hindu undivided family, and perhaps Vrinda would enlighten us on this. But to my knowledge, the Hindu undivided family probably still stands. So what is the Hindu undivided family? It's a legal institution that gives tax benefits only to Hindus. This is, but all citizens of India should ideally be governed by the largely gender-just Indian Succession Act of 25, which is currently applicable only to Christians and Parsis. So in that sense, Muslim personal law is already modern, because since the 1930s it has enshrined individual rights to property, unlike Hindu law, in which the family's natural condition is assumed to be joint. So there's this Hindu undivided family thing, which gives Hindus tax benefits. It's there, and I would be interested in knowing what the Nyaya Samhita has done to it. But if you are going to talk about a uniform civil code with the best features of every law, then certainly the Hindu undivided family has to be abolished. Now, the other interesting thing is, if you think of marriage as a sacrament versus marriage as a contract, the Hindu marriage is a sacrament, the Muslim marriage is a contract. Now, the sacrament means it's something that it's done before nothing less than God. God has ordained this relationship, so obviously this means that this is not a relationship that can be treated in a modern sense, like two people, equal partners, how should we live, how should we share our assets, etc. Whereas the Muslim marriage is a legally binding contract which does protect women better in cases of divorce than does the Hindu marriage. What is also interesting is that if you look at work done on, for example, family courts, Maitri, who did her PhD from JNU, has looked at family courts and the way they function for minority women in India and Hindu women in Bangladesh, Muslim women in India and Hindu women in Bangladesh. You actually see how among Muslims the kind of stigma that attaches to divorce, patriarchy functions in both cases. Patriarchy is no less. But the stigma of divorce is much less. So she keeps seeing people in family courts who are, she's married, now her parents want her, she's divorced, parents want to marry her again because they don't want her to be single. So it's another matter, so and I'll come to that we need to think about marriage very seriously. If we are going to, I want to go beyond the discussion of uniform civil code alone and think about this institution of marriage which is at the center of everything. So setting that aside for now, I'll come to that. Among Muslims, the stigma of divorce is much less. And it seems to be taken normally that if a woman is divorced, she might marry again. So now supposing we say that we're taking the best of every law, personal law, then all marriages should be contracts. So you can see how patently impossible it is to even make such suggestions, right? You can't just say, let's take the best of every religious personal law and make a uniform civil code, because then one might say, let all marriages be contracts. One would have to say, dissolve the Hindu undivided family, and so on, but you can't even make such. The patent impossibility of making such suggestions arises from the fact that the UCC has nothing at all to do with gender justice. It is entirely part of a Hindu nationalist agenda. The other two being the construction of the Ram Mandir, where the Babri Masjid once stood, and the revocation of Article 370. And this was the third. These are the three items on the agenda of Hindu Raj. So how can we treat the UCC as if it has nothing to do with Hindu Raj? As I keep saying now with the Uttarakhand Code, it's almost like people would be like, yeah, we know that now. But we know that now. They've actually given us a sense of what we can expect. So I think I will. I'll talk about some of the features. Some things can come up in the discussion later. Vrinda also has to leave. So I want us to pose the question differently: who suffers in the absence of a uniform civil code? Let's ask the question in that way. Who suffers in the absence of a uniform civil code? In the current phase of BJP rule since 2014, gender justice is explicitly invoked by Hindu nationalists while discussing a UCC. So in that sense, I guess the feminists won. It's a hollow victory, but at least we've made them say gender justice, gender justice, gender justice. We've made them say that. Earlier it was always national integrity. It still is also national integrity, but so gender justice is explicitly invoked, but only for Muslim women who have, of course, long been seen as victims of polygamy and triple talaq. But for decades, feminist legal practice has, without a uniform civil code, used on behalf of countless Muslim women, successfully used both the Protection of Women from Domestic Violence Act 2005, which is available to all Indian citizens regardless of religious identity, as well as the Muslim Women Protection of Rights from Divorce Act of 1986 to deal with polygamy and triple talaq. These two laws have been used very creatively by women, by feminist lawyers, not necessarily women, by feminist lawyers to protect the rights of Muslim women. So you don't, again, need a UCC for that. We know the triple talaq was outlawed in 2019, but this came out of where? It came out of a massive grassroots movement by the Bharatiya Muslim Mahila Andolan, which is a Muslim women's grassroots movement, and it has over 100,000 women as members. It has actively campaigned. It won this case. It was not a gift of the Modi-led government to Muslim women. It was something that they fought for and got. But what is interesting is that soon after that, the next step was taken by Parliament to criminalize triple talaq. So it's very interesting that marriage then takes Muslim marriage and divorce into the domain of criminal law, not civil law. But what remains uncriminalized in this country? Triple talaq is criminalized. Marital rape is not criminalized. So it has been, this paradox has been noted by feminist lawyers that it is a crime for Muslim men to unilaterally declare divorce, but it is not a crime for a man of any community to unilaterally force his wife to have sex. This tells us everything we need to know about the institution of heterosexual marriage and Hindu Rashtra. About polygamy, it needs to be said that while that men across communities are polygamous, across communities, it's not only Muslim men who are polygamous. Many men, it's very common, there's a lot of migration in the country, men live in one place, their home is in another place. It's very common. Polygamy across the board is common. But what happens is that under Sharia law, polygamy has a legal standing. And so what happens is that technically at least, wives can claim maintenance, can claim justice. There's a certain legal recognition of that position of the wife. But that's not there under Hindu law. So there are no rights or obligations towards second wives. Now, if gender justice, and this I'll conclude with this for now, if gender justice is the value we espouse, rather than monogamy per se, are we saying let's end polygamy and enshrine monogamy as the most valuable, sacred thing? Certainly feminists are not saying that. So we need to really be thinking beyond polygamy as bad and monogamy as good. We need to think about how to protect, if gender justice is the value we espouse rather than monogamy per se, we should be thinking about how to protect this category called wife in the patriarchal institution of marriage. Wives are produced through the institution of compulsory heterosexual marriage, which is sustained by the unpaid productive and reproductive labor of women. Almost all women are exclusively trained only to be wives. That is the only training most women get, not only in this country. Thus, when a marriage fails to fulfill its patriarchal promise of security in return for that labor, all that most women are left with is the capacity for unskilled labor, or they remain trapped in marriage with children to provide for while men marry again, legally or otherwise, producing still more dependent and exploited wives and children for whom they need to take no responsibility. If gender justice is the point of legal reforms, the centrality and power of marriage and the damage it can do to women is what must be mitigated. That would mean recognizing, at least as a first step, the reality of multiple wives as a common practice across communities and the protection of the rights of all women in such relationships. I just want to end by saying that the number of times you would have noticed in 2023 alone, the number of times the government and courts have declared that marriage is an institution that they are committed to protect. You would have noticed the number of cases in which different courts have said this. So I'll give you a couple of examples, and with that, a judgment on surrogacy for single women. Surrogacy is only permitted to married men and women. Single men and single women cannot avail of surrogacy. But in that judgment, the judge said, a single woman opposed the court wanting the right to avail of surrogacy, and the judge said, women can't have it all. You can't have it all. If you're not married, then you chose not to have children by surrogacy. So that's too bad. Or the Allahabad High Court, which is of course our model of what the courts are going to be. Every judgment of the Allahabad High Court is absolutely brilliant in this sense. The Allahabad High Court refused to protect an interfaith couple. Vrinda, I'm done. Oh, okay. Yeah, actually, he's not even attending the talk.
He's not. He's a security man.
Why is he taking pictures?
अगर आप सुनना चाहते हैं आके बैठिए, अच्छा होगा, कानून के बारे में बता रहे हैं, आइए। सिक्योरिटी वालों को कानून के बारे में सुनना चाहिए, आइए। मैं हिंदी में बोल देती हूँ।
I'll just finish. So the Allahabad High Court refused to, has done a couple of things. It refused an interfaith couple. One partner was seeking habeas corpus on an unmarried lover being kept prisoner by their family. And the Allahabad High Court said, we are not living in a Western country. Which we did not know till they told us. And so you refused to protect the interfaith couple. The Allahabad High Court again refused to entertain the plea of an adult Muslim woman living with her Hindu partner. She sought protection from the court because her family was harassing her. The court, the Allahabad High Court, declared that a married Muslim woman living with someone else is zina and haram under Sharia law, said the Allahabad High Court. And this is, her husband had actually already left her, he had married again, she was living with this Hindu man, and as adult citizens of this country, they were seeking protection from the court, and this is what the Allahabad High Court said. So the invocation of the Sharia was obviously just a cover for Brahminical patriarchy again, and the reimposition of controls over women's autonomy and self-determination. So that's why we must never have a uniform anything. Now I hand over to you.